While the Trademarks Act allows for the registration of non-traditional signs such as colours, the process of obtaining registration of colour trademarks remains far from easy. An applicant must be able to show that the colour is capable of distinguishing its goods or services from those of other traders, either inherently or as a result of reputation. This video illustrates when colour can be protected through the tests of inherently adapted to distinguish and distinctiveness through association. In Filmac and Register of Trademarks, Filmac sought to register a trademark for the colour terracotta as applied to the connecting insert of polypipe fittings. The Register of Trademarks found the colour did not satisfy the requirements of the Trademarks Act because it had no inherent capacity to distinguish the applicant's goods from that of others. To qualify for registration, Filmac had to show either the colour terracotta was inherently adapted to distinguish its goods or it had through prior use become capable of distinguishing those goods. Justice Mansfield applied the principles in Clark Equipment and Registrar of Trademarks. The circumstances in which a colour applied to goods will be inherently adapted to distinguish are limited to the following. Colour conveying a particular technical result. A colour may become a feature that serves to improve the product's functionality or durability. In Filmac, black was ordinarily applied to piping to protect the product from deterioration through exposure to ultraviolet light. Colours conveying a generally accepted meaning. The concepts of stop, go and danger are conveyed as colours. Application for the colour red applied to taps might fail to satisfy the test in Clark Equipment because registration of such colour mark would undermine the right of traders in taps from using the colour red to convey the meaning of hot it ordinarily possesses. Colours which are the natural colour of goods. If Filmac were to apply for the registration of the colour terracotta to roof tiles or pottery, granting the registration would force upon other traders a method of production departing from the natural mode of manufacturing terracotta products. Colours for which there is competitive need. Justice Mansfield considered the pink bats case. In circumstances where there is a proven competitive need for colours to remain available, it is not an unreasonable restriction on the acquisition of trademark rights to preclude the granting of a monopoly in a colour applied to goods. The colour depletion theory was also considered here. There is a limited range of colours to choose from, and this range becomes reduced through registration of a colour. The court is reluctant to award monopoly over every registered colour as it deprives other traders of similar goods of the common right to make honest use of colours forming part of the common heritage. The court found the colour was not inherently adapted to distinguish. However, as a result of Filmac's extensive use and promotion, it was distinctive in respect of the narrow range of goods. A specific shade of colour can function as a trademark. Application requires evidence of use. You must show you have used the colour as a trademark and that the public have come to identify that colour with your particular product. In Darrell chocolate shops, Cadbury filed an application to register trademarks consisting of various shades of purple. Justice Finkelstein in BP and Woolworths was considered in determining how evidence of the use of the colours in question by the applicant and others should be interpreted. It is necessary to determine whether the trader has used the colour in a way that informs the public the product emanates from a particular source. Cadbury licensed the colour for use on goods outside the description chocolate. This went towards the treatment of purple as a trademark and education and familiarisation of the public that it was a trademark of Cadbury. Thus, Cadbury was able to show acquired distinctiveness for that particular shade of purple. Colour may be registered as a trademark. Like any trademark, a colour must be able to distinguish the applicant's goods and services from those of another. The path to obtaining protection of colour as a trademark will remain a difficult one, and as such the courts remain hesitant to afford protection. What is required is direct evidence demonstrating that the colour itself acts as a distinctive badge of origin. The courts have determined a single colour is unlikely to be inherently adapted to distinguish, whereas a combination of colours may have some degree of inherent adaptation. It remains to be determined on a case-by-case basis.